Mr. Oginski, I almost died. I'm telling you, I almost died. Do you want me to share with you why almost doesn't count? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. I will often get phone calls from injured victims who tell me, listen, Mr. Oginski, I almost died. I could have died. And then I have to break the news to them. Almost doesn't count. When we bring a lawsuit seeking compensation for the injuries that you suffered because of someone else's carelessness, maybe it was a careless driver, maybe it was a careless doctor or hospital staff, almost doesn't count. But what I do tell these people is, listen, we can try and bring a claim, if we have the valid basis for it, for your pain and the suffering that you endured. We can now bring a claim for psychological anxiety, for psychological issues and problems that you now have as a result of somebody else's carelessness. That is one component of damages that we can try and include if you have a valid basis for a case. But the mere fact that you could have died does not rise to the level of what we call a compensable claim. So some callers turn around and say, well, I guess it would have been better if I died. Well, the reality is no, it would not have been better. Your family wouldn't have liked it. They wouldn't have appreciated that. From a legal standpoint, it also is likely not going to help you if you died. Why? Because there are a whole host of other issues that arise in a wrongful death case. In a wrongful death case, one of the most important questions I ask is, listen, what was the financial loss to the family as a result of your loved one's death? So I'm trying to find out if the person who died was working. Were they providing financial assistance to anyone in the family? What were they doing with the money that they were earning? If they were not earning, there may be no financial loss to the family, and that's known as pecuniary loss. And if there's no pecuniary loss, financial loss, now that eliminates a significant component of a wrongful death lawsuit. So then we go back and look at the pain and the suffering that you endured from the time of the incident until the time that the person passed away. That is a limited pain and suffering claim. And there are other types of damages that may be available as well. But when a caller says, but I could have died, doesn't count when deciding whether or not to go forward with a lawsuit. So why do I share this great information with you? I share it with you to give you an insight and an understanding into what goes on when people call believing that they have a valid basis for a case simply because they almost died. You know, I recognize you've got questions or concerns about your own particular matter. Well, if you're contemplating bringing a lawsuit for something that happened to you here in the state of New York and you've got questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.